Suggested that they want to put 4 roundabouts on the state highway, Highway 169, 4 of them. And I can tell you the folks in my community are absolutely opposed to these in the community. In the recession, I know that nearly 90%
Oh, there we go.
There you are. Okay.
Thank you for your patience. Having experienced them, I think it's very, very effective in certain circumstances, particularly when you have traffic coming forth from multiple directions all at the same time and it's consistent flow of traffic. Roundabouts can be very effective. However, on state highways, where you have speeds 45, perhaps 55 miles an hour, I do not see them being an appropriate intersection on a state highway.
Apologize for being a little bit late. We had a caucus that ran a little later than we had anticipated, so we appreciate your patience. This is a subcommittee for Senate File 11 having to do with joint physical custody. We want to give everybody an opportunity to speak that wants to. I would like to start with somebody that can, if there is somebody that fits this category, tell us what the bill's about and why they think that we need it. I think we had a bill similar to this last year, so it's probably not unfamiliar to a lot of people. But if somebody would like to start off and tell us why we need this bill and what it does.
Yeah, my name's Jennifer English. I was present last year as well with this similar bill. So this bill is the rebuttable presumption of shared parenting. What that does then will, in family law custody cases, it will set up the presumption that both parents will have equal parenting time, with the rebuttable portion being in cases of domestic violence and other abuses and things like that.
This would be physical custody as well as legal custody.
Correct, yes. And for me, the biggest reason that we need a bill like this is to mitigate the conflict that is often involved when we see debates going on between families regarding custody. There's a level of conflict involved in splitting a relationship anyway. But I believe, and I think most of the supporters here believe that this bill would help diminish that, since a lot of the conflict involved in divorce and custody cases is just trying to fight for as much time as you can have with your child. And any parent knows, that time that you get with your child is invaluable, absolutely priceless. And in many, many cases, we're seeing a parent getting granted 25% of the year with their child. So they're going from 365 days to 91. And that's just a huge disparity. It's not doing our kids any justice at all. From my own experience as a child of divorce, married to a man who is also divorced, and raised by a stepfather who himself and his child were both the victim of parental alienation. I've seen it from many angles. And I, in my husband's case, he was every day with his child. It was great. They went moving forward. She claimed domestic violence against herself and their child. The judge ended up determining that those were unfounded claims. Yet going forward, the order for protection that she had initially filed for was used against him time and time again, even though there was no proof of abuse and a judge had even ruled, against that. So to be taken down, to be treated as though he is a subpar parent in this case, I mean, that's what you're telling these people involved, that one parent is worth more time than another. So from that, he was at least seeing his child weekly. It was definitely not ideal, but he was seeing her weekly. And then when she petitioned to move, that same order for protection was used against him, and she was granted the ability to move, and then he was only seeing his daughter every 6 weeks. From that, she moved to Colorado without a word to anybody. So now he's in a situation where he's seeing her as her school breaks allow, which is 75 days a year. That's not enough time to build a lasting relationship with your child. It's just not. And we can say, quality over quantity. That's just not true. It's just not. You can't maintain quality without quantity. And I've watched their relationship suffer. My own relationship with my father suffered from a similar situation. It's just not what's best for Iowa's kids. And this presumption is just a starting point. Should someone have an honest, disagreement with that, if the other parent just honestly doesn't want shared parenting, that's not a requirement. But it should be the basis. It should be where we start. Yeah, so that we don't have the fight. Because no child needs to see that.
Okay, thank you. Is there someone who would like to speak against the bill? Like I said, I want to give everybody a chance to speak that wants to. I think it might set the stage if there's somebody here that would like to give us some reasons why they think we shouldn't. Ann, go ahead.
I can start. I'll try to speak loud enough so that I
Yeah, I know,
can be
we
heard
got competition.
over the people behind me. I'm Diane Dornberg. I'm legislative chair for the Family and Juvenile Law section of the Iowa State Bar. I'm a lawyer. I spent 25 years in legal aid situations. The past 18 years in private practice. I've represented moms, I've represented dads, I've represented kids. I've represented people who wanted joint physical care and didn't get it. I've represented people who didn't want joint physical care and got it. The whole range of things. I'm a mediator. I've been a mediator for 20 years. Parenting coordinator for the past 10 years. Represent kids. Court-appointed neutral in a number of situations. And also do collaborative divorce. And parenting coordination, which is after people go to court and spill blood in the courthouse, in that small space with each other and their lawyers, and somebody wins and somebody loses, then they come and sit around a table with me and they try and figure out how they're going to be co-parents together. And that's really hard. It's the hardest thing I've ever done as a lawyer. It's most rewarding because you can make some progress. Once they've done this trial and have that pain and misery and all that blood spilled on the courthouse walls, it's really hard. And we oppose joint physical care as a presumption. We don't oppose joint physical care where it's suitable. And our Iowa Supreme Court has set out 4 standards that need to be met when somebody asks for joint physical care. If somebody asks for joint physical care, then the court has to consider it. And the 4 criteria are really good. When the bill was drafted, the current law was drafted, there were not those details, but the Supreme Court has done an excellent job of coming up with what are good criteria for the awarding of joint physical care.
Is this something you're going to give us a copy of?
I will give you the whole thing.
You've got copies for...
Yeah, I think Jenny had copies,
Okay.
and we'll certainly get you more. But the 4 factors that I want to mention are, the 4 factors that the Supreme Court looks at are stability and continuity for the child, that the parents have a degree of communication and mutual respect, the parents have not had high discord and conflict, and that the parents have a reasonable ability to agree on matters involving routine care of the child, which is important because there's no trump card. All parents are exactly equal. They have to be able to move forward in some way.
Could I ask you a question
Yes.
about that?
Yep.
I think we all know, as a rule, the mother gets the physical custody. Now, not always, I understand, but that's certainly my impression. But I'm wondering, given these requirements, could in some cases there be an incentive for one of the parents not to get along in order to not trigger the idea that you could have joint custody. Would that be a strategy to avoid joint?
That happens,
custody?
but I have, last year when I was here, I had looked at 57 Iowa appeals court cases, and there have been about 20 more that I've looked at, and several things I've learned from reading 75 cases. One is that trial courts are very good at being able to sort out real disputes from ones that are just manufactured to try to avoid joint physical care. I have found that trial courts are very good at sifting through allegations of domestic violence, allegations of alienation, all kinds of things. Trial courts are very good at these. And the result is that in the cases, and this is just the cases that were appealed, and these are decisions, one from the Iowa Supreme Court and the rest from the Iowa Court of Appeals, was that about half the time the moms got custody, and about half the time either dad got primary care or joint physical care. So yes, there used to be, way back when I started, there was the tender years presumption that kids under a certain age belonged with the mother. And that's really eroded over the years, and that's really not what happens.
Well, let me ask you about that now. You're talking about cases that were hotly contested and ended up in the appeals courts.
Yes.
Do you have any statistics about cases that didn't go that way? And
That
what
has
the
been
ratio would be there?
That's been very difficult. I don't know if there's anybody here from the court system, but trying to track that down is very difficult.
Okay.
And judges will give us anecdotal evidence, but trying to track down numbers of what actually happens in court, you know, every case that goes to court has so many facts. When I have a custody trial, it's going to be 3 days. It's going to be 3 days, and that's a lot of facts and evidence and stuff. So trying to sort out all of that, court administration does not have a very good way to do that, and that would be the best source of information.
It just occurs to me that the kind of cases you're talking about would tend to be the more unusual or extreme cases where somebody took it upon themselves to actually go through the whole court system. I wonder if the average person wouldn't have the resources or might not have the inclination to do that, and they just accept whatever went on at the local level. So
There is some of that, yes.
I really have serious questions about whether we can generalize from your statistics from the appellate courts.
Right.
Can I say something?
Well, I don't want to cut her off,
Sorry.
but I want to hear everybody, but let's let her finish first.
Thank you.
Yeah.
Thanks. So several nonpartisan groups have done studies about joint physical care presumptions, and so you're going to hear there are lots and lots of studies, and I think Jenny may have more information about some of the studies that have been done. Minnesota did a very in-depth Supreme Court task force on joint physical care, and the Association of Family and Conciliation Courts had a very detailed think tank on joint physical care. The Association of Family and Conciliation Courts is a collection of people that includes lawyers, researchers, teachers, policymakers, and they came up with 4 major conclusions, I guess 5 major conclusions at the end of their multidisciplinary work. And the reason that they are an important source of information is because they want cooperative parenting. Their goal is to have cooperative parenting, as opposed to some of the researchers who have a bias when they start. Some researchers want to find that joint physical care doesn't work. Some researchers want to find that it does work, but the AFCC is neutral, and so these were their conclusions.
I assume researchers don't admit that. That's somebody's conclusion about various researchers.
There's so much research and so much critical comment on the research. We could spend days just going through the research that's been done.
Okay. arriving at different conclusions, I presume,
Yes,
from what you
all
just
over
said.
the place, yeah.
Okay.
So that's why I go to something like the AFCC, which is not taking a position. Their conclusions were the most effective decision-making about parenting time after separation or divorce must be case-specific. That militates against joint physical care presumption.
Excuse me,
Yes.
why would it? You're gonna have a presumption one way or the other. It's not like you have no presumptions and you just go out and start.
Well,
You're
Iowa
gonna
code
have a
gives,
presumption.
right, Iowa code gives us the presumption that children will have the maximum continuing ongoing physical and emotional contact with both parents unless there's a risk of harm to the parent or the child.
Okay, well, everybody agree with that.
So that, yeah, right, and that's the presumption that the Iowa courts start with.
But that's not a presumption on joint physical care or not.
No,
So
No.
we
It's
need to address
maximum
that
contact.
issue. Yeah, we all agree with that.
Yep.
Everybody
Yep.
wants
Yep.
maximum contact, what's best for the children
Yep.
and all that.
yeah. So the second conclusion of the AFCC was that statutory presumptions prescribing specific allocations of time are not supportable because there's no prescription that will fit all or even the majority of families. Third is social science strongly supports shared parenting in the sense of frequent, continuing, and meaningful contact when both parents agree to it. And then there's also some support, which we talked about, for shared parenting under different conditions. Some forms of conflict or disagreement between parents and relating to the ages of kids. Their fourth conclusion was that there's no one-size-fits-all shared parenting time, even for the most vulnerable families. And their fifth conclusion was that a majority of the think tank thinks that participants supported a presumption for joint decision-making, which is what we've been talking about, which is the joint legal custody. So, I don't want to take up too much time, but I'm going to tell you about a family that I was recently the neutral for. I was the child and family reporter in a family that had 4 kids. And they were 10, 12, 14, and 16-year-old kids. The 16-year-old is a boy. He was in high school. He was getting ready to launch. He shared a lot of interests with his dad. He wanted to live with his dad. The next one was a 14-year-old girl, very typical middle school 14-year-old girl who really wanted everything to be fair and equal. She wanted equal time with both parents. The 12-year-old girl had a terrible relationship with her dad. She was miserable. She felt bullied by him. She felt picked on by him. She cried every time she talked about him. Everything that he did to try to help things out made it worse. The more time he spent with her, the unhappier she got. And the 10-year-old was a happy-go-lucky little girl. Her mom had been a stay-at-home mom. She had closely attached herself with her mom, and she wanted to stay with her mom. But she really thought, she was 10, she thought, I'll be good. I'm good. I can do anything I want. So one size fits all doesn't even fit 4 kids in this one family. The boy, the conclusion was the boy was going to live with his dad. Shared decision making on all the kids, but the boy was going to live with his dad because that's what he wanted. It was beneficial for him. It gave him his launch pad. And he really, really did not want to be in 2 separate places. He really needed to have a home base. And having 2 separate home bases that switched back and forth was just more than he could handle because he had so much going on. The 14-year-old girl was good going back and forth, so she was going to go back and forth every other week with both parents, and she was happy with that. And the 2 little girls, especially the one who was so unhappy with her dad, ended up in her mom's physical care. Joint physical care would have made things way worse for her. So if we take just those 4 kids in that one family, there's no one size fits all, even for the 4 kids in that one family. And a presumption would say one size fits all for all kids in all families, and it's just not true. will give up my time to.
Okay, well, a number of people wanted to comment, so let's, go ahead.
I'm Jeff Jansen. I'm an attorney, a family law attorney here in Des Moines. I'm a member of FUAN. I'm part of the family law and juvenile bar section. And I don't agree with the bar on this topic. Being in the family law area, this is the majority of the income that I get. And just to be frank, I said this last year, passing this bill will hurt my bottom line. So when you have conflicting cases, you have to go to trial, you have to try these cases, you're racking up billable hours. Billable hours mean more money in my pocket. This bill will help eliminate that. There's a rebuttable presumption that sets everybody at an equal footing. I believe there's going to be less conflict. As the bar's study shows, 50% of the time women on the appeals, women get primary custody, and then the other 50 is split between men and 50-50 shared care. That's not equal. The court's not doing this equal. We can all agree that maximum time with each parent is what's best for the kid, and why not start that? That would be with the rebuttable presumption of shared parenting. And although cases may be specific case by case, that's why it's rebuttable. If there's domestic violence, we can overcome that and get past that in a case, and that's one that would probably need to go to trial, and the court would need to hear that. But a lot of times this comes down to money, and who has money, who can make allegations first. And the court right now, in their opinions on these cases on the trial court level, when joint fiscal care is being requested, they kind of just shoot it out. They don't address it. They don't list specific factors. With this new legislation, they would have to point out specifically why they're deviating from and rebutting that presumption. I think that needs to be done because there is inequality in these cases. It does cost a lot of money to do an appeal. It does cost a lot of money to do the initial custody case. So a lot of times these individuals are tapped out and can't follow through. And a lot of times child support's a factor. Having a rebuttable presumption sets them in an equal playing field and doesn't make it that the father's always going to be paying child support. And in order to not have to pay an outrageous amount of child support, he has to go to trial and fight to even get equal footing. So I think for many reasons, rebuttable presumption for shared parenting is what's right. And although it's case by case, that can be addressed. That's why it's rebuttable presumption.
Hi there, I'm Laura Hesper, I gotta put my readers on, sorry, with the Iowa Coalition Against Domestic Violence. We urge legislators to reject SF11. This bill proposes a harmful solution to address the concerns of some parents who are not awarded equalized placement in custody proceedings. While we wonder whether this resolution is either desired by all parents, our concerns are specifically focused on families impacted by domestic violence and the devastating impact this could have on victim and child safety. SF11 is an unprecedented inversion of the values enshrined in current law. Instead of allowing judges to have discretion to consider factors that prioritize the best interests of the child, so that's where we start. Current law starts with prioritizing best interests of the child. And then it puts the burden on parents, the objecting parents, to provide evidence to the contrary. It turns this on its head. So it starts by requiring judges to presume that 50-50 placement is in the best interest of everyone. So that is without regard to the needs of the child, the developmental age, the desire of the children, how far apart the parents live. And it places the burden on the person who objects. In my case, the domestic violence victim, to overcome this legal presumption by clear and convincing evidence. This is a much higher burden of proof and an unbelievably difficult task. The exemptions for domestic violence in this bill do not address those concerns. I can go into that in detail if you'd like. At the end of my comments, I want to first make a couple points first. Equalized placement is likely to apply to cases that involve family violence. Like I said, over 90% of custody cases are resolved by parties that agree. They come to agreement about what they want. The small percentage of contested cases are the most high conflict and risk response. A presumption of equalized placement would only apply to this small group, and which research has found are far more likely to involve some form of family violence. Amicably divorcing people do not need an equal parenting law. They are able to work out their issues They can, decide what's best for their children, whether that be 50-50 schedules or not. To protect families and children, we want courts to be engaged and to have discretion to act on the best interests of families and children. Look, having a good relationship with children does not require equal placement. Fact is, kids do have to go to school, and so unless you live right next door, you can't expect a kid in a 50-50 situation to, attend two different schools. Blanket application for equalized placement would put domestic violence victims and their children in dangerous contact with an abuser. Cooperation, communication, compromise, and safety are all necessary components of a 50-50 placement. Even in the best of situations, with highly committed parents who are willing to cooperate, live next door to each other or in the same vicinity, this is difficult. These components are not present in every household. Many children in general just can't thrive under these circumstances. But in a domestic violence situation, this arrangement is extremely dangerous. It keeps victims and children in a situation they were trying to escape. Pursuing equal placement is not always done out of a desire to spend time with the child. With domestic violence, the abusive partner frequently uses custody proceedings to prevent the victim from leaving, and it frequently works, as many victims decide to stay rather than risk leaving a child alone with a harmful parent. For victims who do leave, equalized placement gives abusers and partners legal opportunity and access to continue to coerce, harass, threaten, emotionally, physically abuse them all. And it puts children right in the middle. To be blunt, this bill tries to have it both ways. We often blame victims and we ask, why don't they leave? And bills like this would make it extremely hard for them to do so. And to the contrary, it's well documented that children do best with the least amount of conflict. And studies show among divorcing parents, equal placement actually increases the conflict. We don't believe that every parent who has ever been violent should never have placement with his or her child. We don't believe that. In fact, many victims want their kids to have a relationship with their children, but they do not desire to put their children at risk. So please reject the notion that a presumption of equal placement is in the best interest of children. We should not artificially limit courts' ability to account for all the facts and dynamics of particular families. This bill prevents courts from giving meaningful consideration to the safety needs of domestic violence victims and their children, and that's why we oppose this bill.
It seems to me hard to accept the fact you seem to be asserting that courts aren't going to be able to handle a situation where there's abuse or whatever if we have joint physical custody. I find that really difficult to accept, that the courts are going to be so hamstrung that they won't be able to do it and take that into account. That's what they're supposed to take into account according to the bill.
Right, but what happens in a domestic violence, leaving basically, I think most people here or everyone would agree that leaving is the most dangerous time for a domestic violent victim. So many victims make a decision. First of all, many victims, we have a family law clinic. Many victims strategically decide never to bring up the abuse in a custody proceeding because she fears the retribution of her abuser. So that doesn't come up in the case. So that's one reason why it might not come up. Another reason it might not come up is that maybe domestic violence, if you understand the domestics of, the dynamics of domestic violence, there's not always, some of the abuse is not criminally actionable. Many victims don't call the police, and sometimes in the highest violent situations, they don't, because they fear for their children or their, or what could happen. So meeting the burden of proof would require a very skilled lawyer and a lot of evidence. And most domestic violence victims don't have that kind of money, so why would we start with a presumption that puts the burden on this person who is in fear for her children and herself to have to prove that? Right now we start with the burden being on the objecting parents. We start with the belief that the best interest of the child is best served.
They're always going to have that as a standard.
But this doesn't. This takes that standard away. It starts with presumption that 50-50 time is best for kids.
Those are two separate things. What's best interest of the child, that's always the standard. 50-50 isn't the same thing as best interest of the child.
It is not the same thing. his best
Depends
interest.
on the circumstance.
Right,
It's a
so,
presumption.
but you're starting with the presumption that it is in the best interest of the child, 50-50. And that's not a good place to start.
Okay, all right. Well, let's,
I mean, shared parenting's good. Children thrive when they have a relationship with both people, but requiring them to have 50-50 time is a much different story.
well, let's keep going here. I want to cover everybody. Go ahead.
You're answering everything.
She just told us that the courts do a very good job of what she's saying they don't. She's saying they don't do a good job. They don't know what's going on, and this bill's gonna kill them. Either she's not telling the way it is, or she's not telling the way it is. If we can't rely on the judge to do the right thing, then why are we sitting here for? Because that bill, or any bill we put out, is no good, because the judge is gonna handle it right anyway. One of these two people, you know, either the judge knows and is gonna handle it right, like she says they did, or the judge doesn't know and should be on the bench like she says they are. So the bill, and she says that bill there is gonna take and put the burden of proof on, let's just say the lady, because she'd be the one being insulted. But the way it is now, the burden of proof comes on me as a male, as a father. I have to go to court and I have to prove that I'm a good father, I'm a good husband, and we're getting divorced because of whatever reason. So with this bill, at least we have a chance. Without it, we don't have a chance.
Go ahead.
Good afternoon. My name is Toya Johnson. I am the Executive Director of Families United Action Network, and I deal with our family preservation stabilization. I'm here today to support a bill that I believe promotes and contributes to the health and mental well-being of children and their families involved in high conflict or never married custody disputes. I'd like to thank all of the senators here for taking the time to meet with us, as well as making sure that public commentary was heard on the matter. I'd also like to thank all of the nonprofit family advocacy organizations such as FUAN, Iowa Citizens for Justice, Americans for Shared Parenting, Parental Guardians of Iowa, and the many other advocates and organizations across this nation. I'd also like to thank the bar as well as all of those individuals who will offer their thoughts on this matter. Whether you are for or against the bill, I hope that we can agree to be respectfully disagreeable in our discussion. There are over 100 studies that confirm, that overwhelmingly confirm that children fare better when they have the opportunity and access to both parents. There were also noted changes in relationships and outcomes when children have the guidance of both parents as well. Our Constitution and case law has duly upheld the rights of parents to parent their children. Has duly upheld the rights to children to have a familiar relationship with both of their parents. And I believe totally that starting with shared parenting 50-50 at the beginning allows for that to happen. If we're going to address domestic violence, most of the time when women are in domestic violence, they have went to the police, they have went to the court, so there's already a record of some sort in many cases that I've seen that happens. So when a divorce is filed, those things can be taken into consideration at the beginning of the divorce proceedings. Also, we also see never married people having the same problem. So let's also consider those people who were never married and they want to be in their children's lives as well. I believe that this can provide a great foundation for those parents to make waves into getting into their children's lives and taking care of their children. I believe that the state should have the strictest of policies when it comes to the infringement upon parent-child relationships, and that if we're going to be acting in the best interest of children, that we do what's in the best interest of the family. There are plenty of apps or applications or other technological advances that have been made in order to facilitate an easier transition for children, whether it's an app that tells what the kids' activities are or who needs to pick them up. There are many technological advances that will allow for shared parenting to be facilitated even in some of the highest of conflicts that there are. Thank you very much, sir. You're good.
I mean, anybody, I thought somebody back here, I thought I was kind of,
Yeah, sorry, I had something to say, but Jeff Jensen pretty much did it. But I
Oh,
did
okay.
want to point out that with everything that, I'm sorry, what was your name? Diane said she's not a psychologist. She doesn't know what was in the best interest of those kids. And basically that.
I'm Darren Clark, just an advocate for shared parenting. I had shared parenting for 14 months, and then my ex-wife decided to file. I met with Phil Garland, my attorney, and he recommended, he's like, in case she does something stupid, you're not going to get shared parenting. I wanted shared parenting. I didn't want primary custody because kids need both their mother and father actively involved in their lives. And that's the original intent of the relationship, is we're going to raise them together. And why not keep the original intent of the relationship? But I didn't want to live with my kids just moving away. So we went to court. We went to court 3 times. When she filed, she kept the kids away from me. Before, we were doing every other day joint custody. So then the temporary order, we had to go back to our joint custody. And then right before my daughter started school, she moved to a different school district just to create more conflict in there. My child was ordered to go back to the 4-city school district until the final hearing. And at the final hearing, the judge says both parents are capable parents, but because now there's some conflict with the couple, and she's in a different school district, the mother was given primary custody just because her work schedule was more restricted. I'm in a situation right now. I noticed the impact it was having on my kids. I got a letter from my daughter, I've shared it before, but this just came from I think she was 8 or 9 years old at the time. She said on Friday, just before spring break, I was in the bathroom sobbing. We didn't have any tissues. I used the whole roll, so I used it up once. It seemed like I'd cry for an hour. I missed dinner because I was sleeping. Divorce controls your feelings a lot. It can make you mean, lonely, or an outsider person or a kid. It just twisted my brother's mind. People think he's a bully, but he's not. He's just hurt me inside. I'm a lonely one. When we had shared parenting, my kids didn't have any problems, other than just a little bit. Once the custody stopped, my son had over 100 incident cases in the first year, being sent to the principal, hitting, kicking. I got actively involved with my kids. I started volunteering in the school every Thursday afternoon. I'd go and volunteer. Did that for a number of years. The more time I was able to spend with him, he started being better. The school had to hire somebody to follow him around in class. Shared parenting works. Your kids are crying out for help. It was the original intent of the relationship. Thank you.
thank you. Yes.
When I was in law enforcement, I was in law enforcement for 14 years. When I was in law enforcement, basically the cornerstone of the law is you're innocent until proven guilty. Rebuttable presumption does to family law what innocent until proven guilty is to criminal. Nobody has a problem. Nobody says it's a cookie cutter approach when you're considered innocent until proven guilty in criminal. Like if you're accused of something. So I don't understand why there's such a problem with a rebuttable presumption in family law when it can be rebutted. If there's something wrong, you're abusive, whatever, it can be rebutted. You're just innocent until proven guilty. Currently, that's not the case. I feel like it needs to change.
Thank you. Yes, sir.
So, Cole Mayer, I work at Kids First Law Center. It's a nonprofit where we represent kids in divorce and custody matters, and we are opposed to a rebuttable presumption of automatically having joint care, and there are a couple reasons for that. The main one is that what we actually see are that the cases where parents agree, those don't come back on modification as often, right? And so when you have this rebuttable presumption, you are now de-incentivizing mediation. And what's going to happen is people are not going to work out. The best mediations are the ones where nobody gets exactly what they want, right? You're going to have parents who are going to say, nope, I'm going to go to mediation, I'm going to show up, but I've got this rebuttable presumption now. And so I'm going to go to court instead. I don't have an incentive to try to work out some hard issues because I know I can go to court and automatically get joint. And that's a problem. When I work with kids, the number one thing kids ask for is that if parents get along and work out what I'm going to do. And when we cut down those opportunities for parents to talk to each other and decide what's best for their kids, even if they didn't like it, but they decide what's best, those are cases where kids do better, they are less likely to come back. And having a rebuttable presumption of joint care also doesn't even take into consideration the 600B cases that are going to be affected by this, because the statute applies to 600B as well, where it's paternity and custody. A lot of those cases, you may only have one parent involved. So you go to court, automatically you're in joint care, and now you have a kid who's maybe not been a parent, automatically introduce this person, you're their half time. And that is terrifying for kids. If you've ever worked with kids in that situation, that is terrifying. There's no ability to build it up. It's an automatic presumption of joint care. And other pieces that I had, like, there were some comments about opportunity and access to both parents is the best. That's great. Opportunity and access does not automatically mean joint physical care. You can have opportunity and access to both your parents with one parent having primary, one parent not having just parenting time. That provides opportunity and access. That provides you an opportunity to talk to both parents. Just because it's not exactly joint or shared doesn't mean you're denied completely from both parents, from one parent or the other.
We do think there are a lot of really great jobs out there right now that are available for islands.
The other issue I have is that
anyone who is available and able to work is working, and then
what
also
we're going to also see
the trust fund for, unfortunately, when there's going to be another recession, that it is sustainable and stable, and that there's going to be.
Go ahead, if you have questions.
Well, I'm having trouble following the logic that if you don't have joint custody, then people negotiate, work things out. If you do have joint custody, some reason that's going to blow all that up and people won't. I don't get that. Why wouldn't they negotiate either way? Because you don't know for sure what's going to happen. Isn't there always an incentive for parties to work things out, whether you have joint custody or not?
Well, so ideologically, yes. Realistically, no. And what I mean is if you're in mediation and you're not willing to give an inch because you know you can go and get joint physical custody, you don't go anywhere in mediation, right? So,
well, how would you know that?
Just because
if you're not cooperating, I would think that'd be a strike against you. If you're wanting joint custody,
right,
and you're really stubborn and refuse to mediate and so on,
right.
If I was in that position, I'd be really worried that I've set myself up to have the judge say, well, we don't want this person.
Well, so just kind of as a side note, mediation's confidential. You can't really say who didn't want a mediation, right? But practically, when parents have less to give on, like if they're essentially if we're not going to go through these factors and look at these factors that have been laid out in the statute and laid out by the courts as to when we should have certain different parenting schedules, then why would I as a parent, if I want joint, why would I give on anything else if I know I can go to court and get that?
Well, turn that around. Let's say you know you don't have joint.
Yep.
Why would you give on anything then? You turn that argument exactly around.
Sure. But the reality is though, when you have that issue, when you have that scenario, you actually have people offering to give up or work on different pieces, and those get resolved and those get settled. That's the practical thing I see. The other one is that our judges know how to sort out what you're talking about as far as rebuttable presumption. We've talked about domestic violence. There hasn't been anything else identified that's going to be a rebuttable presumption, right, so far, because that's specified in the statute. That's a huge gray area that's going to cause a lot of litigation, right? And so,
why is it going to create any more than it does now?
Because what I guess you're going to have parents, you're going to have a judge saying, okay, I think this is a factor I'm considering that is rebutting the presumption, right? And that's going to get taken up on appeal.
Well, I think they consider that no matter what we did here. They're always going to consider violence, aren't they?
So yes, domestic violence is one, right? And that's one piece, but the rebuttable presumption in general, right, is not limited just to domestic violence, correct?
Right. Any claim, I guess, you would have to overcome a presumption, but
so Yeah, but, and what I'm saying is that judges are taking into those things that could possibly be presumption, or rebut that presumption. They're already taking those into consideration when they're making determinations, right?
But they're starting from a different place.
No, they're not, though.
Well, sure they are. Now, they're not starting with the presumption of joint custody. Now, they're starting that isn't the presumption.
There's no, right, so where they start is, there's no presumption as far as where kids spend time, right?
But
downtown anymore.
abuse
My mom worked in insurance, my
of
dad,
violence,
he was a lawyer.
that's gonna be a
I
factor.
said, well, I
whether you
really
have
didn't want to
Agreed.
joint physical custody or
Labor
not.
side, I wanted to follow my
And I agree with you. I'm saying that's one factor we've listed out. We haven't identified all these other
Ended up
factors.
working in a
And
restaurant.
where a court is better situated than the legislature is to say, we have these individual factors we need to look at. And based on these,
And that was to kill a computer.
that is why they order a certain level of care, or who has shared, who has primary,
But I was gonna learn.
and to have clear convincing is huge.
I
So
went and applied for that.
it's a
job,
huge standard.
Knowing that I was underqualified, but they gave me that
Okay,
job.
thank you. Let's,
Since then.
anybody else? Yes, go ahead.
I guess, did I hear you, I might have heard you incorrectly. Did you say that if a young man finds himself
The computer
in a
industry.
spot where he doesn't want custody, and now he's stuck as a joint,
Other places.
ended up in
joint
custody?
John Deere.
Isn't that the ultimate rebuttal of the presumption that I don't want half custody?
It might be, we don't know, right? We don't know based on this.
Going out and applying.
And I'm not looking, is there any?
Took out, they actually took out in the language.
Right,
And that might be the
Agree or
breakthrough I
disagree.
need.
and that's what I'm tracking on, so,
They took out what?
Agree or disagree
right?
of the factors, so what?
Here, I mean, go ahead, because I am a little bit curious here a little bit.
No, I'm tracking with what you're saying, but what I'm also saying is like, this doesn't give a court the ability to do like what we call like a tiered schedule, where you say, hey, there's been this big change in a kid's life, or now we have this parent who wants to be involved.
Okay.
Like, this takes out a lot of the ability for a court to have a tiered schedule, and say, we start here, and we move up to these different levels of visitation.
Actually, among the cases that I read, there was one case where neither parent wanted joint physical care. And the trial court gave joint physical care to both parents. Somebody appealed it, and the Court of Appeals upheld it.
Well, I can understand that when both say no. Yep. I mean, somebody's got it, and it's like, okay, that part makes sense actually to me. But having somebody, and I'm gonna read this again.
Yeah, because they took that piece out.
But I am a little bit curious, if one side says I want, and one side says I don't, that sounds like the ultimate rebuttal.
It might be, I mean,
And I even respect your word might, I mean, because we don't, but yet the point is, one wants, one doesn't, there's a rebuttal. There's a like, I don't want it, and the other person does. I got a hard time.
but what Diane is also saying is that we've had cases where, and actually, I had a trial like this a month and a half ago. I have two parents saying, they both said they wanted primary, right? The judge said, you guys are squabbling over things that really aren't make or break issues, you're gonna have joint, and you can work it out. Okay, and it worked, and it's been working. Yeah. And so judges do that even if we have two parents saying, yeah, I don't know if this, I'm not great about this. But that judge had the ability to weigh all the factors in that case and say, this is what's best for this kid. That, what happens with a rebuttal presumption is that gets taken away.
That's so absolutely not true. I mean, I don't get how you're saying that it's absolutely true. Here's the deal. When you get married or lay down with someone and you decide to have these kids, you go into it expecting to raise the children together first. Just because the parents don't want each other anymore doesn't mean that the children should suffer because their parents still want them. If a parent so decides that they don't want to have that type of responsibility, they can still take the conventional route of divorce and say, look, this is what we're going to do in this case. That's still good parenting because that parent has recognized that they did not have what it took to do that. So I don't get, what I do understand is that she's saying there's blood all over the courtroom. Well, instead of doing that, let's start at the point where there's no blood on the courtroom walls and start from there, because then there's not too much fight when a father or a mother knows that they they have the ability to say, okay, on Tuesday, Thursday, and Friday, my schedule is open, and this and this and that. There's too much technology for your argument to continue to stand. The courts have been able to, you're a parent mediator, you know that there's so many programs out here that you can do an app. So your arguments are making absolutely no sense when the court and the law already allows for rebuttable presumption for domestic violence, for all of that. Why? Because you guys are, this type of process puts parents out on the streets. Because the attorneys have so much time built up into this.
And to speak to what Toya was just talking about, we actually use that technology in my husband's current custody, which, let me tell you, was incredibly high conflict. And you know, they've used our Family Wizard. It's been a great organizational app, a communication tool, a money transfer tool. It's eliminated a lot of the conflict that you would typically have in these situations.
I wasn't watching the time. I wasn't either. Nearly up, but thank you so much.
I'll type it. I'll place it.
That'll work, and I would entertain that.
Can I just have one quick comment? Thank you. The Supreme Court has held raising your child as one of the most fundamental constitutional rights that you have. They use strict scrutiny. The United States Supreme Court uses strict scrutiny to talk about your fundamental right to raise your child. How come when it comes to a separation, that automatically flies out the window? You have the fundamental right to raise your child. Why doesn't that translate to the Iowa Code? The fundamental right to have that same amount of time as the other parent to raise your child. And that should be a rebuttable presumption. That should be held at the highest standard. The Supreme Court uses strict scrutiny, the highest standard. We're not asking for that. I mean, it should
The problem
be
is the case you're talking about is when state action is involved, not parent to parent, and that's why there's strict scrutiny when there's state action, not parent to parent.
Thank you, Jason.
It's a whole different game.